Welcome to another edition of Advanta's webinars, where we provide a lot of just great education and bringing on guest speakers to help get that information out to people on topics related to self-directed IRAs or possibly holding real estate in your IRA account. And today's webinar is exactly one of those particular events that we have where it's focusing on tenancies and evictions. We've brought on an attorney with us today who's going to be speaking on these particular issues. Especially a lot of our clients hold real estate inside their IRA account, and a lot of people maybe listening are just listening for the sake of getting some great information as well on tenancies and evictions. My name is Scott Maurer. I'm the Director of Business Development for Advanta IRA. I've been with the company for over 15 years now. I'm a licensed attorney myself, although I do not practice do any legal work for Advanta clients. So that's why we've brought on a guest today to talk specifically about tenancies, evictions, and what you need to know. Again, whether it's an IRA-owned property or not, you're going to get some great information. My contact information is on this screen. If you have any questions for me regarding self-directed IRAs, you can certainly type them into the chat box. I'm sorry, the question box on your screen. I'll make sure to answer those during the presentation today. Or you can reach out to me at my phone number or email address as well on this particular slide. I'd be happy to take that question offline and get you the answers that you need. Quick disclaimer we provide for all of our educational events is that we do not provide at Advanta, we do not provide any investment, legal, or tax advice, and we certainly don't endorse any particular investments. The information in our webinars is for educational purposes only. Obviously, today we're talking about landlord issues, tenant issues, and if you need more specific answers on those questions, I would certainly encourage you to contact Conrad Grant, who's going to be our presenter today, or at least another attorney in that field, because at Advanta we cannot answer those specific questions for you. Just a little bit about our company. Those of you who are unfamiliar with Advanta, we've been around for almost 20 years. And the only thing we do at Advanta is self-directed IRA administration. That's holding alternative assets inside of retirement plans. Predominantly, the asset that we hold is real estate. So that's why a lot of our webinars that we have focus on various aspects of real estate investing. We have almost $2 billion in assets under management, and we really set ourselves apart with our concierge level personal service, giving everybody, all clients, a one-touch, one person here at Advanta IRA to help them with whatever they need regarding their accounts. The Learning Center, another big commitment to our clients and contacts besides the customer service, is our education through our events, our video library, and certainly our blog articles as well. We do record all of our webinars, so if you ever are unable to attend a live version of the webinar, make sure to sign up for it. We will email you the recording link for that webinar. We place that link on our YouTube page as well, so if you've missed something in the past, you can always go to that website, our YouTube page, and find any past recorded webinar. One event that I wanted to highlight just very quickly, for those of you who are unaware, we offer an event every other Friday where we do allow for people to pitch and promote different types of investments. We call it our Pitch, Promote, and Prosper. It's more of an online marketplace and networking forum where whoever attends that meeting has the ability, usually has given a minute or two to talk about either what they're looking to buy and looking to invest in, or possibly looking to sell or raise capital for. And again, those events are every other Friday from roughly noon Eastern to 1:30 or so. So if you have an investment opportunity you want to buy or you're looking to sell, this is events for you. Our webinars that we have are educational in nature, but this is a opportunity and a forum for people to actually try to find deals and put deals together within your retirement plan or outside of the plan as well. Now I mentioned the real estate is the most common asset that we have here at Advanta IRA, whether it's the single family homes, either for rentals, for either long-term or short-term, Airbnbs, rehabs, condos, mobile home parks, tax deeds. So many different things you can do in real estate are certainly available to you inside of your retirement plan. When you're buying real estate inside of your IRA account, properties, when you're buying, it needs to be purchased in the name of your IRA. That's something that Advanta IRA, we walk you through that process, making sure the property gets titled correctly. The funds for the purchase comes from your IRA account, and you can partner up with other people. You can use your IRA as partial owner of a property and go tenants in common, with a fellow investor as well. And the income that's generated when you buy real estate inside your IRA does come back to your IRA account, tax-free or tax-deferred, depending on the type of IRA account you have. Additionally, if you own real estate in your IRA account, any bills, any expenses that you have for that real estate has to be paid from the IRA itself. And that's something, again, that Advanta IRA, one of the things that we do as part of our service would be to pay those bills at your direction. You'd submit a copy of your invoice or use our online system to direct us to pay your electric bill, the insurance, property tax bills, your maintenance workers, etc. All those expenses do have to be paid by your IRA account if your IRA owns a piece of real estate. Certainly, we've had clients use property managers who will collect your rents and certainly pay the bills and then send the excess, your net rent each month to Advanta IRA for deposit as well. That's certainly an option that you have within your IRA account. As far as managing the property, the repairs and maintenance, you as the IRA owner cannot perform any services on the property. You cannot paint the walls, you can't mow the grass, replace a water heater, do various little other things around the house. Those things are prohibited under the IRS rules that do not allow any disqualified person from giving their services to the benefit of the IRA. So you as the IRA owner are disqualified, as well as certain family members, your parents, grandparents, children, and grandchildren also are not permitted. But anyone outside of that would certainly be allowed to do the property. You as the IRA owner can choose who does the work. You can certainly inspect the work. There's no requirement that you use a licensed repairman. It is up to you to who you choose to do it, and just again make sure that the IRA pays for those expenses out of the IRA funds. When it comes down to renting the property, it's important, obviously, that you are working with, either if you're working with a property manager, they're probably doing a lot of this work, but if you're not, you are, as the IRA owner, selecting your tenants, you're negotiating the terms of any lease, what the rent income is per month, any other special clauses that you want inside your lease. We'll probably find out a little bit more about that with our next speaker coming on in just a minute. But Advanta IRA will sign the lease on behalf of your IRA account. So Advanta, as the administrator of your IRA, needs to sign all the documents related to the purchase, sale, and in this case, the lease of the property as well. But you're going to select your tenants, determine the terms, and just make sure that your tenant each month, when they're sending their rent check, is forwarding it directly back to your Advanta IRA account for deposit. So again, you can employ a property management company if you choose. They're going to handle a lot of your issue probably that you have. But if you don't, and you are doing this yourself, you're going to want to have someone in your corner to help you out with any potential issues that you have with your landlord or in the tenant relationship. So we've featured today, our guest speaker is attorney Conrad Grant, who focuses on specific landlord-tenant litigation, also does some title and closing work and other general real estate litigation. He's a partner at Kelly & Grant, PA. He's been on with us before. It's been a little while, so we wanted to bring Conrad back on to address some of your questions that you have and go over some basic landlord-tenant rules that you need to know and need to have and understand as the owner of real estate. Again, whether it's in your IRA or not, this presentation will cover that aspect in general. I just want to remind you, as we go through the presentation today, if you have any questions for Conrad, please type your question into the question box. I will make sure that I monitor those questions and get those questions to Conrad as we go along. We'll have some time at the end as well for those questions as well. So at this point, I'm going to turn the presentation over to Conrad. Conrad, this time we're not seeing the presentation yet. We're seeing the Dropbox background. But how are you doing today? Oh, there it is.
I got it. We're up. How are you?
Good. Very good, very good. Yeah, excited to learn more and
Awesome.
hear from you regarding the presentation. So again, if anyone has questions as we go along, type them into the question box. I'll make sure to get them to Conrad. But at this point, Conrad, I'm going to turn everything over to you.
It's Scott. I had one question for you about the limit in your IRA.
Sure.
The real estate. I had typed it in, but is there a limit? I know most IRAs have a limit. So if your real estate were to contribute more than 5,500, whatever the limit is, what
Mhm.
happens? How does that
That's
work?
a, yeah, that's a great question, Conrad. So the IRS does limit an individual each year to how much they can contribute out of their own pocket into their IRA. That is limited to say $6,000 or $7,000 a year. But there is no limitation on earnings within an IRA. So the rental income that comes back to your IRA is considered earnings within the account that has no limit and no cap on it. So whatever you're charging for rent, whatever you're getting on the sale of a house, that's not going to count against that $6,000 or $7,000. That only applies to kind of new money that you're putting in out of your own pocket.
All right. All right. That sounds great. We'll talk offline about that. Thank you.
Okay, sure.
All right. Awesome. Good afternoon, everyone. My name is Conrad Grant. I'm one of the attorneys at the law firm of Kelly and Grant. We're based in Boca. We handle a lot of real estate matters, including homeowners association and condo association, real estate litigation, title and closings, and of course, landlord tenant law. So today we're going to focus on landlord tenant. We are one of the better known, one of the top landlord tenant firms in the state. And so I have a lot of information to share with you. Usually I do this class, I teach this class for CE credits. I've tightened it up for time, but you're still going to get all the information you need. You might see some slides that I'll gloss over, and usually those are examples that if this were presented live, I would ask those questions live and people would answer them. So I'm going to gloss over those. All right, let's get started here. So we're going to start off with non-tenancy issues, and this affects investors a lot. You buy a property and there's a non-tenant in there. There's someone living in there. So we will address how to get rid of those occupants. We're going to talk about what to do during the tenancy. So if you have a bona fide tenancy, what to do during that time, during an eviction, and what to do after the tenant vacates. And as many of you know, the CDC moratorium has been overturned. It's no longer in effect, but I'll touch on some of the implications, and ERAP, which is the government payment system that might be of interest to you. So moving on. Unlawful detainers. So you buy a property and there's the former owner in the property or someone living there. This is not your tenant. This person has never been a tenant. So how do you get rid of that person? Well, we use a process called unlawful detainer. Okay, you'll hear terms, people talking about ejectments and so on, but we're not going to talk about that because those take forever and it's a different process. So unlawful detainer used for squatters and unwanted guests. You need three important legal elements. Legal right to possession of the property, that's number one. Right to possession, it doesn't have to be ownership. You ask the person to leave, that should be done in writing, and they've refused to leave. This never applies to tenants or people who've paid rent. So if if a client comes to me, I'm going to say, has this person ever paid rent? If the answer is yes, then we can't use this process. We typically start by serving a written notice. It's not required by statute, but judges will want to see that you've asked the person to leave, and just saying, Judge, I told him to leave several times. That's not going to be enough because the occupant is going to say, well, you've never told me. It's the same summary procedure as evictions, which means it's an expedited case. Summary procedure is a shortened time frame for lawsuits. And if any of you have ever been part of a civil lawsuit, you know it can take months to years sometimes, but this has to be resolved quickly, typically 6 weeks or so. Another one, motions for writs of possession. Auction property. This is where you might have bought a foreclosure property. When a property is foreclosed on, there is a clause in the final judgment which says that the court shall have the power to issue writs of possession. So we reopen that case and we ask the judge to issue a writ of possession, and then the sheriff will come out and remove whomever is in the property. So usually it's going to be the former owner. You'll, of course, need to get your certificate of title issued by the clerk so we can show that in our pleading, in our motion. Serve a notice to vacate, demand proof of tenancy, and then we file the motion and schedule for a hearing. Most likely it'll be set for a hearing. We tell the judge our side, the judge grants the motion, and a writ gets issued to the sheriff, and the sheriff will come out and remove the person from the property. So many of you might need that. All right, so moving right along. If you have a real tenancy, there's a lease or not, you don't have to have a lease, you're going to run into evictions from time to time. You can evict for non-payment of rent. You can evict for lease violation, termination of month-to-month tenancy, or a tenant just holding over. So let's start off with the most common reason why tenants get evicted. Of course, you became a landlord because you want to collect rent. So this, of course, is very important to your bottom line. So this is not really a 3-day notice, but you need to serve a proper 3-day notice, and this one isn't. Neither is this one. You'd be surprised at the types of 3-day notices that I receive. This is a proper 3-day notice. If you notice at the top, you'll have the tenant information, you have the date, the tenant information, and then you have the body. 3-day notice for non-payment of rent. And the way I created this is just fill in the blanks. Every blank line here is required by statute. You cannot leave any of it out. And then you give you 3 days. You then need to serve that on the tenant, and it could be served by delivering to the tenant personally, where you hand it to them. If the tenant is absent from the premises, then by posting it in a conspicuous place on the premises. And then you have to fill in the landlord information, and you serve it. That's how you serve a 3-day notice. Next. So
hey, Conrad, if I can,
yeah.
I have a quick question for you. So maybe you'll address this here, but you showed some kind of in a sense, a little bit humorous examples there of 3-day notices that are not sufficient.
Right.
Does that create extra headaches down the line if you're actually trying to terminate the tenancy and you kind of served a 3-day notice that was not proper, but then you did follow it up with a one that is statutorily correct? Does it complicate matters of the initial one that you sent to the tenant?
Yeah, it's not a problem. So it's last in time. Your last 3-day notice is what really matters. So a tenant might bring it up and say, hey, you served me this before. It really doesn't matter because each new 3-day notice voids the previous 3-day notice. So it's never a problem, and it's never going to be a defense. Good question, though. Don't be afraid to correct your 3-day notices. So I have clients do that all the time, and it's never been a problem. Thank you.
Right.
So properly terminate. So you have to serve your 3-day notice. All right. You have to use, the landlord has to provide an address. You can't accept rent if the tenant attempts to pay. I'm sorry, you have to accept the rent if the tenant pays in full, because you're asking for the rent. You're saying pay rent or leave. You can't give early notice. So you need to look to your lease to make sure you don't have grace periods. And if you have grace periods, you need to honor your grace periods. You cannot include late charges or utilities. I say cannot, but there's an exception to that. And I'll address that a little later, but it requires putting that information in your lease. Do not include the day the notice was served. Do not include weekends or court holidays. Avoid mailing, or you're going to have to add 5 additional days. And if it's Section 8 housing, you have to mail a copy to the authorities. All right. Section 8 is subsidized housing, where the government will pay, or HUD will pay a percentage, and the tenant is responsible for the rest of it. So here's an example I'm going to run through quickly. So this is one example of you serving a proper 3-day notice and when your complaint would be filed. So in this example, the notice was served on the 16th. Your day 1 is the 17th, day 2 the 18th, day 3 is the 19th. You have to skip weekends and holidays, so I could not file your complaint for eviction until the 15th. All right, and if we moved this, the notice was served on the 15th as an example, then we would have 1, 2, 3. The notice would expire on Thursday, and I could file your complaint on the 12th, saving you some time. All right, on the Friday, which would save you some time. So keep that in mind when you serve your notice is important. If you serve your notice during holidays or right before holidays, you're going to lose extra time also. Prior to serving your notice, I can't tell you how many times landlords get this wrong, where the notice has the wrong amount on it. They just kind of wing it. Consult your ledger, okay? You always need to have a ledger. Sometimes judges ask for it. You can only demand actual rent unless your lease deems any miscellaneous ledger entries as additional rent. So you could say, for example, late fees are a late fee of $100 if the tenant is late, 5 days late, and this late fee is deemed additional rent. So now something that's not rent, we've made it into rent. So if rent was $1,000 per month, that late fee, once it kicks in, you now have $1,100 per month, and you can claim that. You can do this with late fees, utilities, if you are the one paying the utilities, administrative fees, repairs, and so on. If your 3-day notice is incorrect, it can significantly delay your case. And in some jurisdictions, Orange County as an example, your case can actually get dismissed, or you would need to serve a new notice and amend your case. So it can take a longer time. Just do your notice correctly, okay? I'm going to skip that example. So during the 3-day notice period, if a tenant attempts to pay you rent in full, you must accept. Remember that. You have to accept it. If it's partial rent, you may accept and give a new notice. So I'll give you the example for that. The tenant owes you $1,000. You post the notice. The tenant shows up with $800. That's a decent amount of money. So you could accept that and immediately give that tenant a 3-day notice for $200. You could also just outright reject the $800, especially if you want that tenant gone. After the 3-day notice expires, so this, what I just explained was during the notice period, during 3 days. After the notice expires, you can accept the money and do a new notice, or you can reject completely and just move forward with an eviction. After filing the eviction, do not accept any money, okay? If the tenant deposits it into your account, you need to let me know and let your attorney know, or if you're doing it yourself, you need to send that money back, okay? If you accept that money, if it's a good amount of money and you accept it, that's fine. You have to dismiss your case though. And here's the tip. If you're doing this without an attorney, tenant files answer, or the tenant gives you money. Let's say the tenant deposits it and you keep the money. And then you decide to dismiss your case because you have your $5,000. If there's an attorney on the other side, you could owe attorney's fees because you started this suit and you voluntarily dismissed the suit, and that attorney could go after attorney's fees on behalf of his client. So keep that in mind, all right? I've seen it happen many times. The landlord gets the money, dismisses the case, there is an attorney on the other side. You can also enter into an agreement. So if this money is there, you don't want to turn the money down, you could get together with the tenant and enter into a joint stipulation for settlement, which is an agreement between you and the tenant, the investor and the tenant, and the court has the power to enforce that agreement. So if the agreement was tenant agrees to make payments in 2 installments, a payment on October 15th and another on November 1st, and the tenant fails to make any of those payments, you don't need to file a new suit. You would just ask the court to reopen the case and issue a writ of possession.
Conrad, if I can interrupt you a second, we had a couple questions come in on the 3-day notice. I'm pretty sure you answered 2 of them. I mean, 2 of them were basically the same, and that's, again, the question was if somebody pays partial rent and you accept it, do you have to serve another 3-day notice for the additional rent not paid? If I'm reading everything correctly, what you said, yes, you can accept partial rent, but you have to then file another 3-day notice for the amount still missing.
That's correct. Yep.
Okay.
That's what I recommend.
Yep. And then the next question is, if I collect last month's rent in the lease, so I guess up front when they're getting their tenant, they accept the
Hmm.
last month's rent, and in the last month they fail to pay, or I said in the fifth month they fail to pay the 5 months rent, and I
Yeah.
serve them a 3-day notice.
You can, yes, because the last month rent, you don't know when the last month is. So you cannot unilaterally say, well, tenant, this is your last month, so I'm going to keep this. You don't know when that last month is, so serve your 3-day notice. Now, if the tenant comes back and says, listen, I lost my job, I just got a new job, I won't get paid until next month, can you apply my last month rent to September? And you both agree, that's fine. But just because you're holding a last month rent doesn't mean you cannot serve a 3-day notice. I hope I answered the question. You should still serve your 3-day notice because you don't know when that last month is yet. If the
Gotcha.
tenant tells you though that, hey, I'm going to move out at the end of October, and so now the tenant has told you that if you didn't get October rent, because we're in October now, if you didn't get October rent and the tenant told you that in writing, then you have no right to give a 3-day notice because the tenant has told you that he or she will be moving this month. So you're going to apply that last month rent. But if November rolls around and the tenant is still in the property, then you serve a 3-day notice for November. All right? Make sense?
Okay, absolutely. Yep. Thanks for answering those questions. People that are listening, keep the questions coming. Conrad, I'll
Awesome.
turn it back over to you.
Awesome. So after filing the eviction, as I said, stipulation is one of the best ways to go. Uh, so now we can terminate month-to-month tenancies. So that was non-payment. How about terminating month-to-month tenancies? First, a month-to-month tenancy can be created just orally. Landlord and tenant meet each other, and landlord has a property to rent, tenant moves in, and they agree verbally just to pay money. That's a month-to-month tenancy. Another method is the lease expires and it's not been renewed. There's no automatic renewal clause, but the tenant stays in the property and the landlord collects the 13th month of rent. It becomes a month-to-month tenancy. Some landlords like month-to-month tenancies because you can terminate them with a 15-day notice. If it's Miami, city of Miami, it's not just the city of Miami, actually, it's Miami-Dade County. As of January, Miami-Dade County now requires a 30-day notice. But for all other 66 counties, it's still a 15-day notice. You must serve that 15-day notice before the end of the rental period, and you have to make sure that the termination is not retaliatory. I'm going to give you some examples. So, 15-day notice. So if rent here is due on the first of every month, the landlord wants to terminate this tenancy, the landlord has to serve this notice, in this example, by August 16th, because the landlord needs to have 15 days left in the month, and then the tenant would have to move out on the 1st. So the way you do it, because it doesn't have to be the 1st, that rent is due. It could be the 15th, it could be the 10th, it could be the 11th. So how do you navigate that? Well, the notice needs, this is a trick, the notice needs to expire the day before rent is due. So now it doesn't really matter whether it's the 8th, 9th, 10th that rent is due. It doesn't matter. As long as your notice expires the day before rent is due, and when you count backwards in time to present time, you have 15 days, then you're good. All right? But in this case, I'm going to make it easy. Rent is due on the 1st. This landlord has 15 days. So this notice would need to expire on the 31st, and the tenant would have to leave by the 1st of September. And if the tenant doesn't leave, the landlord can start eviction. All right, here's an example. Lease expired a month ago. Parties never renewed. Landlord accepted rent. Under the lease, rent was due on the 15th day of every month. When can the landlord serve the notice, and when does it expire? So in this case, the landlord can serve the notice. I'll start backwards. The notice is going to expire on the 14th because I just said here that rent is due on the 15th day of every month. So using my method, this notice is going to expire on the 14th. That's the day before rent is due. And then we're going to count backwards in time. and the day to serve the notice would have been July 30th, with day one being the 31st. All right, so that's how this would work, and the notice would then expire on August 14th. Moving on, as I said, you're getting a crash course here. Lease violations. This is another method of evicting a tenant for lease violation. And this is the least preferred way to evict tenants, because in the other two, the burden is on the tenant to show that either your 3-day notice is wrong, or the payment you're demanding is wrong, or that you don't have a month-to-month tenancy. Whatever it is, the burden is on the tenant to defend and win that case. When you're going for lease violation, the burden is on the landlord to show that the tenant has violated the lease, and it's never easy. The first thing you have to do is give a 7-day notice to cure. Most breaches are considered curable. Unwanted guests, unauthorized pets, you have very few non-curable breaches. So the bottom line, keep in mind that if your tenant is violating the lease, whether it's loud music, unauthorized guests, you have to give a notice to cure. You can't just say, I want you to leave. All right. Here's an example of a 7-day notice to cure. And I've divided, I'm not going to go through the entire thing, but you're going to address it to the tenant. The last paragraph where it says demand is hereby given to you, that should always be in your 7-day notice. That's required by statute. And then the middle, here, number one, I said you haven't changed your air conditioning filter, which is your responsibility under paragraph 10 of your lease agreement. So that's weak. The next one is you changed the locks and you didn't give the landlord a copy of the keys, which is a violation of paragraph 15 of your lease. Please give the landlord a copy of the keys. And then finally, you made unauthorized alterations. Paragraph 17 of your lease prohibits this. You've altered the premises by changing the locks, or by building a tiki hut, or installing an above ground pool, whatever it is, you state the violation. So 3 things. You state what the issue is, state the paragraph of the lease that the tenant is violating, and tell them what they need to do to cure it. That's it. Pretty simple. And that's your 7-day notice. If you don't do it that way, a court can consider it vague, and you would have to serve a new one. So you have to serve a notice to the tenant to cure, and then you gather all your evidence, and before you go to court. So here's some evidence gathered by previous landlords, unauthorized occupant, unsanitary conditions. I'm going to put all these up. I can send everyone, all the attendees, a copy of this slide, but I'll go ahead and I'll skip the examples here. I think you kind of get it, that, it can be for hoarding garbage, having a boyfriend in the property that's not on the lease, or as number 4 says, tenant punched another tenant, threatened to kill him with a knife, and that would be one of those non-curables.
Yeah, and Conrad, I actually had a question come up, I think, just almost specifically on that axis. So it says, do you have to have verbiage in the lease prohibiting unwanted guests? Does it have to be in the lease specifying that? What kind of rights do you have as the landlord in those situations?
So in that example, yes, most leases will have that. But in the case, if you don't have it, if you came to me, you said, the tenant has an unauthorized guest in the property, I'll look to the lease first. And then I'll look to the statute, because the statute will fill in some gaps. In this case, I don't remember off the top of my head if the statute talks about not having a guest. In fact, it doesn't. But it will address other things. So if the unauthorized guest is making noise or causing unreasonable disturbance, then I can find a way to do that. But I would say an unauthorized guest needs to be in a lease. That would need to be in the lease. Other things I can find in the statute. And that's important to note. If it's not in your lease, the statute does a good job of filling in those gaps. but it doesn't do it all the time.
Right, and maybe, and actually, one other question. Maybe
Yeah, no
that
problem.
what you just said will answer it. So the question is, does the tenant have to inform in writing before the lease expires, or the landlord has to inform in writing to ask for renewal? And I guess, like you said, that might come down to what is specified in the lease, and then if
Yeah,
it's
that's an excellent question. So in Florida, leases naturally expire, right? So if the lease is supposed to expire October 31st, then it expires. You don't have to remind the tenant to move. The tenant doesn't have to remind you. You should be able to show up on November 1st and take possession of that property or set up a walkthrough. Now, so that's how the law works. Now, you still need to look to your lease because many landlords add things to their leases. You know, they'll add about renewal periods and so on. I'm not a fan of that. I think you should not put yourself in that box where, say tenant needs to give me 30 days notice if he's leaving, because then you have to give the tenant 30 days. It's reciprocal. So you have to do that. And you don't want to say landlord needs to give tenant 30 days, because what if you don't remember? This person, then it automatically renews and the person is in your property. But if you leave that open, then all you have to do is remember, even if it's a day before, you could say, hey, Bob, just checking to make sure you're leaving tomorrow, because it's not in your lease. The law kicks in and they're supposed to leave automatically. So that was a very good question. Bottom line is, I did a lot of talking. The bottom line is this, that unless it's in your lease, you don't need to give any notice of non-renewal. The tenant doesn't need to give you one either. And I would rather you keep that out of your lease. All right.
gotcha. Okay, all right, can continue on.
So the eviction process. All right. So as I said, crash course, eviction process. How does it work? The time frame is going to be about 4 weeks if a case is uncontested, and I'll explain. Uncontested is the tenant doesn't answer. Another 2 weeks if it's contested. So this is a very fast lawsuit. I like these because the turnover is very quick. First, you have to deliver your notice. Let's go with 3-day notice. You deliver your notice, the notice expires, tenant didn't pay. Then we file your eviction in county court. County court has jurisdiction over all evictions. The clerk will issue a summons. The process server will serve the tenant with a 5-day summons. 5 days, not 20, 5. Tenant has 5 days to answer, and if the tenant doesn't answer, then we ask the clerk for a default, to issue a default. Then we submit a final judgment to the judge. The judge will then take a few days, 10 days on average, to enter the final judgment. That means you've won the case at that point. You have a final judgment for possession against the tenant. You then take or send the writ of possession to the sheriff. The sheriff will then post a 24-hour notice. Now, the sheriff is out of my control. They do it based on their manpower. So it could be a week before they go to the property to post that 24-hour notice, and they could take a week to come back. The sheriff will then call the landlord. So I'll put the landlord's information on the writ. The sheriff will call the landlord and say, hey, I'm going to be at the property on Friday at 10 a.m. Be there and bring your locksmith. And you show up. And if the tenant is still in the property, the sheriff will remove the tenant, tell them they have to leave. And if they return to the property, then that's criminal trespass at that point. And the sheriff will turn over possession to the landlord. You can change the locks. If there's furniture inside, you can throw them out at that point. That's what the law says. You have no liability. You place them on the curb, or if it's a single family house, at the curb or the designated disposal spot if it's a community. So that's the process in a nutshell. It sounds easy. There are steps in between, but it really boils down to those steps. So there's some additional things I want to touch upon. If it's a service member, so for example, when we file a motion for default, we have to do a military search to make sure that the person is not in the military. And if the person comes up as active duty, then we're not going to get a default because this person could have been deployed. I've been doing this for 10 years, and that's only come up twice. But what will happen is we'll have to let the judge know, and the judge might set a hearing and so on. It's usually resolved quickly based on my experience. But it protects the service member from, getting kicked out just because they had to do some duty. Eviction process. What if the tenant answers? So remember what we talked about previously was a default. Tenant didn't answer, we get a default, we're done in 4 weeks. If the tenant files an answer and you're a property manager, some property managers file their own eviction, you will need an attorney at that point. If it's an LLC or a corporation or some type of entity, the entity must be represented by an attorney. So here's what the judge could do. The judge could order rent into the registry, mediation, a hearing, or a final hearing. It depends on what the tenant says in the answer. We have some other options. We can motion to strike, motion to set cause for trial, or we can settle the case using a joint stipulation for settlement. So I'm going to go a little bit into the joint stipulation for settlement because I think most of you investors will identify more with using this method. The others, the judge is going to order it, or we can do a few things to move the case forward. But at some point, if the tenant's answer says, I know I haven't paid, I didn't have a job, now I have the money, I really want to stay, I know I owe you $2,000, but I have $1,500 and I want to stay, and the landlord wants to agree to that, he would do a joint stipulation for settlement. And it has many advantages. It can defer the eviction fees so the tenant can pay on an installment plan. You can get a fixed move-out date. If the tenant says, I don't want to be here anymore, but I need a little more time because my new property isn't going to be ready until November 1st. You can agree on a hard date. You can agree on a hard move-out date, or you can say, can you move out this weekend? If you move out this weekend, I want to dismiss this case and you won't have an eviction against you. And I will forgive all the money you owe. So you can do those things if you really want the property back. You can avoid spiteful damage to the property because a lot of tenants, when they feel like they have some control over their situation, the sheriff is not throwing them out. They are a part of this negotiation, and you can say, leave the property in clean condition and with all the fixtures in place. And then here's what protects the landlord. If the tenant does not comply with the stipulation, then the landlord lets the judge know that the tenant did not comply, and the judge will order the sheriff to execute the writ of possession. You don't need to file a new suit. All you need to do is just let the judge know by using an affidavit, and the judge will reopen the case. And it could be 4 months later. Maybe the tenant's on a payment plan, and the tenant paid 3 months, and in the 4th month, the tenant does not pay. Or the tenant agreed to move out November 1st, and the tenant doesn't move, and it's now November 5th. We would just let the judge know, and the judge would just enter a final judgment and order a writ of possession to be issued. So I like stipulation agreements because it solves the problem relatively quickly, especially if there's money involved. So I'm going to skip these examples. As I said, they're usually for interactive class. When is a writ of possession necessary? A writ of possession is where the sheriff comes out to the property. I say you should always get a writ of possession because that is the only thing that protects the landlord from liability. Unless the tenants have turned over the keys, removed everything, shut off the utilities, and put something in writing. So I'll have landlords come to me and say, hey, I don't need the writ. My tenant moved out. And I said, I'll say, how do you know they moved out? And if the answer is, a neighbor told me they saw a U-Haul, I will say that's not good enough. Text that tenant. If your tenant texts you back and says, yeah, I left, that's good enough for me because that's in writing. So always try to get something in writing. Hey, Bob, I'm just checking to see if you vacated the property. And he might say, yeah, I left, screw you, you're a terrible landlord. That's okay because now you have the text that he left, and you can take possession. But if you don't have anything in writing, just let the sheriff do it. It'll be 2 more weeks, but it's worth it. Otherwise, you can be liable. Go ahead.
Yeah, Conrad, a question came up kind of talking about a little bit of this question came in, says if the tenant moves out, but they still owe money, so they still didn't fully pay, but they moved out, and then it takes additional funds from the landlord to get rid of the possessions left. The question is,
Yeah.
what recourse does the landlord have
Okay.
to get any remaining payment over, I guess, any amount of deposit that was left?
Yeah, that's a good point. So what I'm talking about here is for possession only. You can do two different lawsuits, or you can combine them. You can combine a possession suit with a suit for damages, which is where you would add money damages going after money from the tenant. I don't do that. I don't encourage landlords to do that because I think it's better to get possession back quickly. When you do it with damages, then you have a 20-day summons to deal with. You have a 5-day summons and a 20-day summons, and the tenant has to be personally served. So it could take longer. So a tenant owes you money, right? That's the question. How do you deal with this? So the tenant vacated. The landlord had to throw things out and hire movers and do all these extra things. The first thing you're going to look to the security deposit, right? If there's a security deposit, you're going to make sure that you can deduct the unpaid rent, the cost of moving, and so on. If there's no security deposit, or the security deposit is not enough, you can just move on with your life, or you can file a suit for damages against the tenant for damages to the property, unpaid rent, the cost of moving, cost of repairs. You can do that. But I always tell my clients, this person could not pay to keep a roof over their heads. Why would you waste time trying to collect damages from them? And some landlords will say, well, I want the judgment to be there for 20 years. At some point, they're going to buy a house and I'm going to get paid. Some landlords are like that, but usually it's not worth it. It's better to just move on. Did that answer your question?
Yeah, I think that answered it perfectly.
All right.
One other question came up too, and I'll get back to it. It said, does it say notice serving has to be through a lawyer if the landlord is away from the property, like in different states? And that's not sure the
No.
whole question there is. I don't know if that makes sense enough to answer.
I think I get it. So if the landlord is out of state, well, all service. So when we think of service, we're thinking about three different stages. The first stage is your 3-day notice, and that can be sent by the landlord, or a process server can serve it, or the landlord's neighbor can post that on the door. It doesn't matter how it gets delivered, and it can be mailed. So that's one, but that's pre-suit. Then you have the summons, which has to be officially served either by the sheriff or by a licensed process server, right? So the landlord isn't directly involved in that. And then finally, the sheriff comes out to do the writ of possession. So I don't know if I answered that question. The landlord would not be serving anything except that notice. Do you think
Yeah,
that?
yeah, and I would say the person who asked the question, if you need more, they didn't say just say that was good response. That's what they were looking for. But say as with any of these questions, we'll have Conrad's information up at the end
Yep.
here in a minute. Make sure you can reach out to him directly. But yeah, go ahead, Conrad.
Yeah, well, should I keep going? Because I'm answering the questions as I go. So,
Yeah, no,
uh,
keep going. Yeah,
yeah,
keep going. We
okay,
still have about 10 minutes or so, and I only have one other
perfect.
question that's there that I was going to leave for the end for now. So,
Okay, awesome.
um,
So that's the writ of possession. I say always get the writ of possession. You don't want to spend 6 weeks on a case and then at the end you decide you want to save $90. You know, who must and should use an attorney? So this kind of leads into that question. Any property owned by a corporation, if the eviction is contested. And I encourage people to use an attorney. It is litigation, but some people are do-it-yourselfers. All right. Property managers in Florida can file evictions. So if you're out of state, you hire a good property manager, they can do it themselves. But if there's an answer, they need to get an attorney. Anyway, most property managers use an attorney for everything anyway. Suing for damages, we just talked about that. Tenant must be collectible, otherwise it's really not worth it. Now, So that was all good. It seems like an attack against the tenant, but here's what a landlord must do. You have a duty to maintain the premises, all right? Always. Um, Florida statute puts these affirmative duties on the landlord. It's roofs, plumbing, screens, heating, extermination, except for single family homes, which you can shift the burden onto the tenant. Some landlords make a lot of mistakes, like not doing repairs timely, not curing code violations. And a tenant has remedies. A tenant can withhold rent or serve a notice and vacate the property. If the property is uninhabitable, a judge can abate rent until the landlord fixes the property. So if it's a one bedroom, one bath, and the bathroom cannot be used, that's constructive eviction. That tenant might not owe rent. If it's two bathrooms, the judge might say, all right, I'm going to reduce rent by $100 per month until you fix this. Mold issues come up a lot, but it's hard to prove for a tenant and hard for a tenant to win. If the tenant says there's mold, you have a duty to investigate and to remediate it. And I would say you would need to do that professionally. Don't just show up with your bottle of bleach and start spraying. Best practices for landlords. Have a system in place at all times. Do not ignore requests for repairs. Communicate all and document everything. And have a hierarchy of emergency versus non-emergency repairs. You just basically need to organize yourself if you're just getting into this business. Section 8, I mentioned that Section 8 tenancies, the housing authority will pay a portion. So the only difference is that you need to notify them when you file a notice or when you're doing an eviction. And you can only demand the portion that the tenant owes. So if Section 8 pays $1,000 and the tenant's responsible for $100 and the tenant's not paying that $100, you can only give you a 3-day notice for the $100, okay? What happens if a tenant dies in the property? 3 things. Then you actually one thing, you have to wait for 60 days to pass. That's the bottom line. So I'm not going to delve into this. If any of you are in that situation, just reach out to me. But you need to wait for 60 days. What if you're filing an eviction and the tenant files bankruptcy? You need an attorney at that point too, because there's an automatic stay in place. And if you continue to pursue the eviction or even to serve a 3-day notice, you could be in violation of bankruptcy rules and you could get sanctioned. All right. So those are your triggers: death of a tenant, tenant in bankruptcy. You need to reach out to an attorney because you do not want to make a mistake there. Security deposits, very important for you to know. If you're returning the deposit, you have no reason to keep it. Do it within 15 days. If you're keeping the deposit, you have 30 days. All right, and you need to serve a notice of intent to retain the deposit. You have 30 days to return it, and you do it by certified mail, and the tenant has 15 days to object in writing. Okay, if you don't do it that way, you forfeit the right to keep that deposit, and the tenant can sue you for its return. Okay. As I said, this is basically what I said. I just explained most of that to you. Ways to improve your return on investment: get a landlord-tenant friendly lease. Don't use grace periods. Don't allow your tenants to fall too far behind. Best to file evictions quickly instead of keep listening to stories. If you have multiple units, tenants will talk to each other. If they find out that you're lenient, don't be surprised if everyone starts being late. And remember your stipulation agreements. Last slide. On the CDC. So I had prepared this, but the CDC order, it got overturned by the Supreme Court. So where do you stand right now is you'll have tenants applying to ERAP, which is the Rental Assistance Program. And you don't have to participate, okay, but it can tie things up. The tenant will file an answer with the court saying they have applied for ERAP, and the judge will send it to mediation. But at the end of the day, you do not have to accept that ERAP money. You can continue to evict the tenant, but the money is there and it's available, and they're paying a back rent, and they're paying 3 to 6 months of future rent. But here's the catch: you have to keep the tenant, okay? Keep that in mind. Keep the tenant. If if you accept the EREP money. All right. And that's pretty much it. That's my crash course. As I said, this is typically a 3-hour course that I teach. I've distilled it. Do you have any questions at this point?
Yep, Conrad, we do. We have a couple other questions that came in, and again, if anyone else is trying to get any in, please do. So we have a few minutes left.
Yep.
Going back to someone who's looking for leverage, I think it's the same person asked a question about tenant moves out and you have to pay for removal of their belongings and they still owe money. The
Mhm.
question is there something they can file that impacts the lessee's, the tenant's credit when the money is owed, even though they've moved out? They're just looking for something like what kind of leverage might you have? Is that something you could do?
Okay, so number one, the first thing you will have is there's going to be a final judgment for eviction. So that person's going to have a hard time renting because every background check, it's going to come up. So that's one. And then some landlords use a collection service. And so those creditors will then start trying to collect from that tenant. And that's one way of putting it on their credit report. And then the third and hardest way is to get the judgment through the court against them. And then so those are your three methods. Collections, if you definitely want it on their credit report, hire a collections agency or company, and they will try to collect as much as they can.
Yeah, and the person followed up and said, well, it's a situation where possibly where they actually do have the attorney, they actually do have the money to pay. They're
Mm.
just, I guess, choosing not to. So I guess, yeah, either filing
Yeah,
something
yeah.
on their credit
Then I
or
would go
getting a
through the
judgment.
courts. Yeah, I
Right.
would go through the courts then to try to get that judgment paid instead of
Okay.
collections. Yep.
Quick question: what can I do if the tenant removes the smoke detectors in the unit? Can I evict? I'm sorry. Can I evict them for this?
No, 7-day notice to cure. First of all, it's your responsibility, the landlord's responsibility to make sure the property has smoke detectors. So if you provided it with smoke detectors, start documenting. You're going to serve a 7-day notice to cure, stating that it's come to my attention, you've removed the smoke detector. Please return the smoke detector within 7 days, or or else. And if the smoke detector was broken and the tenant says it was broken, then the landlord should provide a new one. But if the tenant keeps removing or disabling them, put it in writing in your 7-day notice to cure. And if you want to take the drastic measure of evicting them, you can do so. But your 7-day notice is going to be your documentation for that. But you can evict after your 7-day notice expires.
Okay. Another question said, in the light, and this kind of goes a little bit back to the CDC moratorium, is that instead, in light of past COVID rent collection stays, will entering into short-term 3-month lease allow you to evict at the end of the lease, regardless of any future moratoriums?
Yes, because none of the moratoriums prohibited a landlord for evicting for other reasons. It was only for non-payment of rent. So during the pandemic, we utilized terminations of month-to-month tenancies and lease violations and holdover because we could not do the non-payment of rent. So yeah, if you do a short-term lease, which, keep in mind that your municipality may not allow that, but let's say it does, you do a short-term lease, that might be a way to protect yourself. Some landlords have done a written month-to-month lease. So you can keep the tenant as long as you want. It's written, it's there in writing, so you can enforce everything just the same.
Yeah, and a couple of do two more three more we have three more questions. Get to them quickly. So the first one is,
Yep.
do you handle like delinquent mortgage foreclosure issues at your firm?
Yeah, actually, say that again.
The question was,
Delinquent.
do you handle delinquent mortgage payment or foreclosure issues?
So the investor owns a property and maybe they were a hard money lender or whatever, but they hold the mortgage and they want to foreclose. Is that my
Correct.
understanding of it? Yes, we handle that. We have a litigation attorney, Corey Carano, who handles those. So yes, we do handle foreclose on smaller more, and those are actually easier than the bank foreclosures.
Okay. Another person says that they use week-to-week at-will rental agreements. Can you just quickly touch on the advantages and disadvantages of an week-to-week at-will rental agreement?
Well, the only disadvantage is if it's a good paying tenant, then they can leave in a week. But it works the same as month to month. You give a week to week notice. There aren't any real disadvantages to it. Some people like that. Some tenants like to feel like they're paying less money. But when it comes to evictions, you're going to serve a 7 day notice of termination of week to week tenancy. So there are no disadvantages to it unless maybe your municipality doesn't allow that if you're, if you're a landlord, which you need to check into.
And the last question would be, what do typical attorney costs for, it says, for a non-contested procedure, like through the eviction process?
Sure. So if you go to our website, which is right there, kellygrantlaw.com, it's kellygrantlaw.com. You can see a list of that, but it's going to be $435 for a one tenant eviction, and that includes, it's only $195 attorney fees, and the rest are court costs. So we collect the $435, we pay the costs like the filing fees $195, the summons will be $10, the process server is $40. We keep $195. That's what. If it becomes contested, we charge more. But if it's not contested, great. You only pay your $195 in attorney's fees plus the court costs.
Gotcha. Okay, yeah, and if again, Conrad, thanks again for your time. For the people that were listening, I had a couple of people asking about the slides. You can either get in touch with Conrad for them, or I have a copy of them as well. My information is on this last screen. Just send me a quick email and say, hey, can I have the slides from today's presentation?
Absolutely, send it out.
Yep, and everybody who's listening live will get a copy of the recording. You can respond there as well. And anybody who listens to the recording as well, just email me and I can get you a copy of the slides. But you can send
out my information, Scott. You can send out Conrad at kellygrantlaw.com. They can reach out to me also.
Perfect. We will send that as well. Conrad, thank you so much for your time. I know it was a truncated version. You went through everything though in a very concise fashion. A lot of good information. Again, if anyone has any additional questions, please reach out to him. I think he's demonstrated quite knowledgeable and would easily be able to answer a lot of your questions. So please reach out to him. So Conrad, thank you again for coming today.
All right. Appreciate the opportunity. Thank you. Bye.
All right, again, and thank everyone for listening. And we look forward to seeing you on our next webinar.